Good morning and welcome to the third session of our event planning and management series of the broadcasts. My name's Margaret Hemsley, for those of you that are tuning in for the first time, and I'm drawing on my experience from risk management and business development to guide you through the principles and processes of event planning and risk management. This broadcast, however, has been pre-recorded due to my availability and needing to go and do some work in the country. So we're not taking live questions today. However, you'll be able to email questions in that will be forwarded to me, and I'll give you a personal answer wherever I can. And if it's a question relevant to the whole organisation, we'll send them through to Ros and she can broadcast them back to everybody. So the email is here on the screen, westlink@rdl.wa.gov.au. So that's westlink@rdl.wa.gov.au. So you might want to have your pens ready and some paper throughout the session to take notes, but I'm also happy to make these slides available just to give you some ideas and remind you what we talked about. So today I'll be taking through the topic of risk management from a liability point of view. So this is the probably more scary part of risk management that people always fear the worst. People that hear me speak often will say that I don't like to think of risk management about the bad things, but more about the opportunities. But today we're allowed to dwell in the less savoury aspects of it. So whether you're organising a promotion or a small function in your CRC, or you're involved in a major event, you may be exposed to potential liability action. In other words, somebody might sue you, and that'll come from what's called a third party, which is somebody not associated with you or your organisation. While saying that, you may even face some sort of litigation from within your organisation or your staffing if you breach other forms of legislation. So if this happens, you also need to know what to do next, because the sky won't fall if you get sued. You just have to be prepared to respond. And what you do next is really going to strengthen your defence case. So we'll be talking about that as well. But I do want to stress that today's program is not legal advice. I'm not qualified in that area. What I can do is give you general advice and help you understand better what you need to do, but you need to talk to the specific people if you've got an issue that you're concerned about. And happy to take emails on that if you can think of an area that you need advice on where to go to. So what we're going to do now is to get started is to give you a perspective of what liability is, how it came about, and how to put proactive measures to safeguard you and your CRC, and what to do if things go wrong. So we'll just go to the first slide, just actually to let you know that what we're actually going through is a structured process that will take you on a journey, so that once you understand it, then you'll know what you've got to demonstrate. Then when you understand what you've got to demonstrate to defend yourself, you'll put in those preventative measures, and then we'll talk about what to do when it goes wrong. So starting off liability, a lot of it is about legal obligations, and they came out of three main parts. One is about legislation. Now, legislation is something that's passed in Parliament, whether we agree with it or not. Often we don't. Once it's written in law, you have to comply, and if you don't comply, you have to tell people why not. So you're in the gun to prove that you've complied. The other one you see there about the councils, that is about local laws. The sort of things that come into local laws is what you're allowed to do on council land. It might be about food or health and all of those sort of things, and building structures where you're allowed to hold an event. The third one, and the most tricky one, which is where it's probably the most costly as well, is common law. Now, common law is what you see on the courts, and it's always about historical stuff. So when you start seeing a TV program when it's somebody versus somebody, that's an historical court case that sets a precedent. And then the only way that you can win in a court of law is to have the cleverest lawyer, to be honest, because sometimes it doesn't make sense. So we've got to actually abide by all those things. And when we did the workshops, for those of you that were there, remember we went through the context and we asked what laws do we have to abide by. We were talking about legislation and we were talking about council. The unfortunate thing with common law is you don't actually know what is going to happen unless it happens. So prevention has got to be gut feel in a lot of the ways, and learning from history. So we'll go through a bit of that now, and I'll show you the actual definition that they generally use in legal terms. And in legal terms, the word liability refers to fault. So you owe somebody some duty of care, and it's your fault if something goes wrong until you're proved innocent. The person who is at fault is liable to another because of his or her actions or failure to act. So sometimes it's not what you did wrong, it's sometimes what you didn't do right. So that's a really key point that you need to remember. When we start talking about liability, a lot of people will start to say that if we don't know about it, how can we actually do it? And the problem with law and legislation is that ignorance is actually no defence. So you have to do what's absolutely reasonable to find out what you're supposed to be actually looking at. So when we actually start looking at liability, we're really talking about duty of care. And it's a responsibility to actually take care of someone or something. So liability might arise about property, it might arise about the environment, but more often than not, it actually arises about the care of people. So, and that is the number one criteria that you're actually looking at to do these. Now you might ask, how did that come about? Because it just seems that people bandy around this duty of care, and most people get it, but they don't understand why it suddenly had to be coming into place. Well, it actually comes out of common law, and it's then been transcribed into legislation. But it actually started in 1932. And I'll tell you a story, and it's got pictures, but only small pictures. So it actually started in 1932 with a snail. So it's kind of hard to believe that this onus that's put on everybody could start with a snail. But in 1932, there was a lady who went with another person to go and have a sundae. You know, ginger beer poured over ice cream, you'd say that was really nice. Unfortunately, the snail came to the party as well. And this snail that had been fermenting in the bottle popped into the nice sundae that was there. The lady ingested it and ended up in an emergency department of whatever they had in 1932 in a very sick condition. So subsequent to that, this poor lady has felt that she's owed some damages from this ginger beer company that have actually given her this illness. So she decided to sue. Now there's a couple of things about that, and in those days the women didn't really have a very loud say in things. So for a woman to take on a man's world of manufacturing, there was a lot of ramifications to that. Not the least being that she decided to ask them for £500 in damages. So it was going to cost them money as well. So when she actually got to the court case, and it was all heard in all of the things, of course they did everything they could to actually stop her case. But she actually did win the case eventually. So the guys got together and they actually even went as far as the House of Lords to overturn her case. So argued backwards and forwards, and eventually they came up with a judgment. And the interesting thing about that is that whilst it was then appealed, she was upheld, this was actually what was the statement out of that, which was the ruling, was you must take reasonable care to avoid acts of or omissions which you can reasonably foresee that will be likely to injure your neighbour or another. Now that actual action was going further, but the judge presiding in the case actually died. So it kind of died a natural death, if you like. So because of that, it's never actually been fully challenged to the court of law, but it set a precedent. And everything else that came back after that was linked to that. And some say that's where the legal profession really started, back in that thing, and made so much money out of the duty of care over the years. But when you think about that with the risk management that we've already talked about, that is exactly what it says. You must do what's reasonable and practical to address a foreseeable risk. So this foreseeability keeps coming up, and that means that your planning, like we did in the last session, is really important to understand who you've got to talk to, what you've got to talk to them about, and more importantly, what is your duty of care. And that's quite a lengthy sort of topic to decide. And of course we all know what happens is when a liability arises and somebody sues you, the first thing people are going to do is trying to work out whose fault it is. And it's never the person who actually gets reported to first. And it can bandy around for a long time. The other thing to remember is that the liability span can be up to 20 years. So we'll talk about strategies to deal with that, but somebody can come back and sue you long after you've left the committee, long after even anybody can remember it, and those court cases get lost because there is no information available to remember even who was around. So record keeping is important, and we'll talk about that. So just summarising liability, it's really about you understanding your duty of care. It's about taking reasonable care not to have the snails in the sundaes. That's a very obvious one, but it goes much wider than that. When it comes to a court of law, people will argue about it all, but these days you cannot pretend that you don't understand that you have a duty of care, because it's in legislation, it's in bylaws, and it's actually in pretty much everything we do these days, safety and health, everything, all because of that snail in 1932. So that's just the history, but I think it helps you understand that if you're selling anything, you're providing entertainment, whatever you're doing for anybody, you are providing a service of some way or form. That gives you the duty of care. Which leads us now to trying to work out a bit more. What is it on this slide that says, how do you know if you actually owe someone a duty of care? Well, if you're an event organiser, you owe the person a duty of care, and it's breached when it causes injury or loss. Therefore, you may be liable in negligence, and that's taking lack of proper care or attention. And this arises independently of laws or any other written laws. It's actually a common law. If it arises out of written law, then you're actually breaching state legislation, and they have penalties that go with that. So you have to actually even work out what sort of breach it is, because you'll treat them very differently. The first one you will actually treat with, if it's coming out of any sort of legislation, is you have to pile up the evidence and give everybody as much information as you can to show that you actually did the best you could. If it's common law, you actually give them nothing. You actually don't help them. If they want to sue you, the actual limit of what you do is actually advise your insurers and tell them where to go, not literally where to go, but where to go to see the insurers. Because they have to actually understand what they're actually suing you for. And even under the Freedom of Information Act, they're going to actually have to have a set of documents they're looking for or certain information. So you don't help in that case. You owe them politeness, and that's all. So that's a very key difference between the two. So you just make sure that you don't help hang yourself by throwing out too much information. You'll be guided in that process. And what we'll do when we come a bit to the damage control, I'll show you how a bit more that we can deal with that. So let's go to the next part. Again, as we say, legislation. You do all you can to help. Common law, don't want to know about it. You just flick it off to your lawyers or to somebody else. So now we're going to actually look at the basis to go one step further. So one of the bases for a liability action is that there has to be proximity. And proximity means that they have to have come into your patch, whether invited, whether they're there for legal or illegal reasons, they still have to be in proximity. And then you have to have given them some sort of set of information. So if you were having a very risky sort of event, you would have had to give them some information to say that this activity is dangerous. But we really have to look at the Civil Liability Act, which will do more to extrapolate that. So first realise somebody you invite along comes by themselves, whatever, they're in your patch. So that's what you have to remember. So first it's about my patch. If they're on their patch, they're your problem. The second thing is that foreseeability. And you'll see in this little old cartoon, if you have somebody with guns and with alcohol and such like around the place, somebody's going to get hurt. You can't say that that wasn't foreseeable. So you would be acting like a turkey if you thought that you could do that and get away with it. And then when you look at that, your responsibility is to provide reasonable care. So there you owed those people a duty of care. You invited them out to your place with some guns to do whatever they're going to do, but you allowed them on the site intoxicated. So in that scenario there, would you be liable? Very likely. I think that will be a hard one to argue your way out of, but what you could do is you could end up with a contributory activity, which means that they shouldn't have been doing it in the first place either. So there's a few different things that you can do to actually warn people, tell them what their responsibility is, but ultimately you'll be in the gun first, so to speak. So moving to the next part of that one now. To demonstrate your duty of care, all of the stuff that we were talking about in event planning is you demonstrating your duty of care in whatever way it is. So that chart we went through last time, and for those of you that didn't get involved in that, I'm sure if you get hold of Rosalind, she'll be able to send you out a copy of all the steps you must take. So it's really, at every step, you've actually got to ask yourself, is there any legislation that we have to follow? What's our duty of care in this point? One of the key areas of duty of care that people do well is safety and health, volunteers mostly. One of the things we often forget in our duty of care is our contractors, people that bring other workforces in there, the general residents that are in the area. That's why we have traffic management plans. We have people going through the event. If you didn't have all these sort of things, there's so many avenues that you can actually be sued if it goes wrong. You might recall me talking about, excuse me, you need a drink. You might recall me talking about the businesses. Your duty of care to the businesses is in a different way. It's not to damage their business, because they can suffer a tangible loss if you actually bring in outside traders. So they have a liability suit if they want it. So there's so many pitfalls in this if you really want to look for it, but there's so many people that can give you help and advice. And don't pretend this thing doesn't exist, because it doesn't happen often. But I'm going to share a couple of instances with you later that could happen to anybody if they don't do the right thing. Okay, so let's see what the next part of this is, our risk management plan. So if you see the context of this, your risk management plan is supposed to pick up all of those areas of liability. Firstly, the second half of the opportunity-based risk, which we've talked about, is about achieving your objectives. So put that aside for 1 minute. We're going to actually talk much more at this stage about those risks. When we start bringing them up, we talk about erecting stages. We might talk about trips and falls just coming into your organisation. All of those things you put on your risk management plan. The reason you're putting treatments in place for them is to prevent that duty of care being breached. If you start looking at it like that, the risk management plan doesn't become something painful to do. It's the thing that you do to keep yourself out of the courts. And believe me, you don't want to be there. It's really time consuming and it's really horrible. Consultation is another part of a duty of care. There's some very recent cases where consultation didn't take place, and local knowledge and things like that. So if you're going to an event thinking you know it all because you've done something before, that's the first step to a pitfall. You've got lots of people that can help you. You've got lots of government departments that work in this space. You've got the local governments, you've got local specialists, you've got the exhibition and event organisers on a state level and their peak bodies. Never be too afraid to ask for advice, because if you start doing things without asking, there's lots of local things that, especially if it's not on your patch and you're taking an event to somewhere else, that can really trip you up. And when it does, it's a really horrible thing to see. And the first thing they're going to say is, why didn't you talk to somebody locally? So that's a very important point that you need to look at in that liability prevention in your risk management plan. The second lots of things that you have to look at is who's associated with your event. Now in the main, most of you, if it's a small event, you probably would only be looking at some volunteers, your invited guests and some stakeholders. The bigger your event gets, the more people you've got to talk to. Not only do you have to talk to them, you have to actually write down somewhere in somehow how you've done that communication. So if we look at the Bouncy Council people, what you have to look with them is do they have a work safe certificate for their event thing, or actually their equipment? Do they have a logbook, and can you see their maintenance schedules? Have they got insurance? Do they have a crowd management plan? So if you've got lots of kids wanting to get onto that bouncy castle, do they have restricted numbers so that people don't hurt each other? So all of those things you're not responsible for, but you want to have them demonstrate to you that they've thought about those things. And then that's their responsibility. You can demonstrate that you've done the best you can to make sure that they took their responsibility. When it comes to your volunteers, the other thing that you have with volunteers is that they need to be treated the same as staff under the Safety and Health Act. They need to be registered with your insurers if they're formal volunteers of your event. So even if you just keep a list, that needs to be there of everybody who's got a reason to be there. You might find it odd to wonder why you have to write so much detail, but it's quite amazing how many volunteers who have an injury suddenly say, well, I did it at your event, and you didn't even know they were there, and possibly they weren't. But people look at all angles, so you've got to be a little bit suspicious on one hand, But on the other hand, all of your volunteers have day jobs or day families. If they hurt themselves at your event and you haven't got the volunteers' insurance and you haven't got a list of who they are, there's no evidence that they were there, they're not going to be able to be compensated and get back to their normal life. And that's a really, really important point. When it comes to your stallholders, what they are selling on their stalls and all of those things can actually bite you if you're not careful to make sure that you know what they're doing. You don't actually have to know every little item, but you want to have some sort of thing. If you want to come to my event, I'd like you to tell me roughly what are you selling, what are you doing. Technically, electrical goods is a good example of that. If people have the car boot sale type of thing, selling electrical goods that are not tested and such like could lead to some liability. So a lot of those places are now saying that you can sell anything but nothing that's electrical. So find out from some of your local council or state bodies of what are the sort of things we need to be careful of. There's foodstuffs, there's all, even, would you believe, dogs and cats and things in car boot sales. Some people like to think they can bring those along and sell, and there's regulations around those. And one regulation that's often hidden is that if you're selling new goods and it's not in shopping hours in any particular place, you're actually breaching legislation there. So you have to be very careful when you start setting up these things that you really do understand your legislative requirements as well as those common law things. And then you erect stages. If you erect stages, you're not going to do it, but you need to make sure that everybody else that is there has actually got a white card, which is the safety and health thing. Again, it's commensurate to the size of the stage. If it's just a little platform, maybe not so much, but the bigger the stage, the more you need to have your engineering right. So you've got to get it signed off by the builders with tents and stages and all those kind of things. So once we start looking at those components of things, there's so many different ways that you can get sued, if you like, unless you're transferring the responsibility to the people that are actually doing it. But you become the principal contractor in any of these, and your duty of care is to make sure that they're demonstrating theirs. Otherwise, it can escalate up to you being involved in a lawsuit as well. And the last ones are your food sellers. Even though you've got lots of other things in an event, you must make sure that they all actually do understand the Safe Food Act and all of the issues that go around with their premises and the temperature of foods. And you probably all have heard of the famous coffee case, I think it was obviously in the United States, where somebody was sold a cup of coffee that burnt them. And that set a precedent in law. So you've actually got to be a bit mindful. That's really hard when you've got people saying, but I want a hot cup of coffee. But the people that sell those things, they should be all over that. So just make sure that they know their things, food allergies, warnings and things that they know about. Any doubt with that one, you just refer them to the council, to the environmental health officer, and they can give them all those details that you want. So you can see with an event, it's quite a big picture. One event that I was responsible for many years ago in the health industry was when we held a health expo, and we had all the alternative health practitioners wanting to come along. Apart from having to referee between mainstream medical and alternative health in those days, that was interesting. But we had to find some benchmark as to who was going to be allowed to actually come to this event. And we actually decided at the end of the day that we would say, if you belong to a peak body and you've done some sort of formal training or workshops, that's the minimum standard. Because you'd be amazed in things like aromatherapy and that, people do a weekend course. And it's quite a dangerous activity if you're not really qualified in doing what you're doing. So you have to find some benchmark because otherwise you run into the Equal Opportunity Act of not giving people equal opportunity to demonstrate their wares at your expo. So there's a few little twists and turns that you need to negotiate to do those sort of things. So that's about your third parties that are under your control. So you'll be emailing them and you'll be saying to them, I'd like to know what you're doing. You need to be responsible to that level. I want to see your insurance and I want to have a thorough understanding of what's going on at my event. And if you can demonstrate that in a court of law, they would say that you did what was reasonable and practical to address a foreseeable risk. We know the risks are low, but when things go wrong at events, they can be very drastic. So this is why all of these little steps take place. So let me just give you some examples, and these ones are fairly extreme examples, but I think it's really important that you understand that when you start changing things, putting up tents, inviting people into your backyard, you can have some really big problems. Now this one was actually in Toowoomba in 2011. They had extremely heavy rain. Now that wasn't the event organisers' fault. And the tent started to collapse under this heavy rain. So the first thing is that you start to see something goes wrong. You must have a contingency plan of how you're going to manage that, because this actually involves stopping the show. And you can imagine in a big event like this and a big music festivals and things, how do you stop the show easily? And that's having a plan. So the actual thing that the response that the person made was, these tents are hired in, they're not our tents. We have engineering certificates, signed off with full building approval, which will be from the council. And they will be investigating, I'm sure, and looking into what went wrong, he said. But my immediate priority is to keep the area safe, lower the remainder of the tent that's still partially collapsed. Now, luckily no one was hurt in that event. But you can see that by him responding in that way, he's taking his duty of care. He's also demonstrated his duty of care, saying, well, we did get them structurally looked at, we did get them reported to the council, and we actually have gone through all the things we needed to do. So should even somebody have been hurt in that, that was a weather act that really created it. A secondary thing, however, might have been, were those tents strong enough to withstand the sort of weather that you might have expected on the night? That was an extreme weather episode. But if you look at tents, and you mightn't even realise, they've actually got a wind factor. And if you say some of them might only be winds of, say, 40 kilometres an hour, if you're having an event on the west coast of Western Australia, that would be just a normal sea breeze. So you've got to be really careful when you're talking to people that you've got the right sort of equipment. Now, in that tent collapse, that one had a semi-happy ending, I guess. There was probably a bit of financial loss, but nothing drastic. There's been, in 2011, I think there were 5 episodes around the world that all resulted in death. One had 4 deaths, there was another one with 1 and about 28 people injured. So those big tents that you see are fine while they're up and standing, but if they start to fall and the wind or the weather has an impact, or they're incorrectly erected, there can be some big problems. And financial ones are the least ones that you want to worry about. You want everybody to go home safely. Now, the second event I want to talk about is you've obviously been very aware about the Racing the Planet event in Western Australia that's gone wrong. Last week I actually participated in a forum where the results of the investigation were there. Now, I stress these are not legal investigations. This was an inquiry to see what happened. The legal work is still to come, and it's a watch this space. But it was quite horrifying when you actually had a look at how they did not do their duty of care. So I'm just going to read you a couple of the findings that they had from there. The first finding was that the Racing the Planet people were aware that there'd been fires on and in the vicinity of the course prior to and on the day of the 2011 Kimberley Ultramarathon. Racing the Planet, which are the event organisers, should have been aware that there was a risk fire posed to the competitors, the employees, the contractors, the spectators and the volunteers. They talked then a bit more about the international standard of risk, which we've talked about at the workshops. And the first finding was that they didn't comply with that risk management standard, which was a requirement of the contract, because they did not involve people with appropriate knowledge in identifying the risks. Apparently they came into town and had a few conversations, but not enough to understand the environment. They were overseas people. They didn't communicate and consult adequately with the relevant agencies and individuals on its management and risk assessment plan to identify risks associated with the event. They also found that the risks identified in the management and risk assessment plan appeared to be generic and are notably lacking in identification of cause and consequences. Summarising that basically was that they had a risk management plan done by consultants, didn't involve the event organisers, so they didn't actually know what was in the plan, and it didn't actually address the environment that they came into. Now, Racing the Planet is actually a high-risk thing. They come and do marathons in way out places, so it's a high-risk activity. But there lies the rub. It appears in the communication that they didn't actually communicate a lot of that to the competitors themselves. There's no evidence there, so that will be an interesting one. Because had they communicated how risky it was, that might have reduced their exposure a little. Not a lot, because this was clearly above and beyond the risks that you would expect. So They also didn't contact FISA about the fires the Racing the Planet staff had seen. So along the way, the staff volunteers saw some fires in the distance, but they didn't contact the fire and emergency services at all. So in the days leading up to the race, even though these fires had been seen by the Racing the Planet, they were advised to do so by the Kununurra Visitor Centre and the Department of Environment and Conservation, and they ignored that advice and didn't contact FISA to find out what to do. They didn't contact St John's Ambulance prior to the race, despite being advised to do so by FISA through the Kununurra Visitor Centre. So consequently, the committee that in the inquiry found that Racing the Planet did not take all reasonable steps to identify the risks associated with the marathon. So even their planning, they were found to be wanting. So there's a whole lot more in there, and you can find this, if you just Google Racing the Planet inquiry, you'll find this summary document. But I just thought it would be useful for you to see that there's lots of things in what we're saying about local knowledge, knowing the laws, knowing the terrain, and then responding. And from my experience, most of the things that go horribly wrong in events is when things start to go wrong and everybody can see it, but nobody actually has a plan. How to stop the event? What should we do? Where do we go next? So they're just two big examples. When you go down to the local level, the investigations that I've done over the years into what's happened, they mostly come to things like tea urns and things like that. So somebody gets a burn or a scald, or somebody's clothing gets damaged or something like that. So it's generally lower end of the event in community things. So that gives you an idea of that proximity, that duty of care that's owed and the legislation that's required, the communication and the consultation, looking at those sub-events and the subcontractors and the other things that are going on around. Okay, so what can we do to prevent things? The first thing that we're going to look at is making sure everybody's got insurance. Now, that would not have prevented this accident out there in either of those cases. It wouldn't have prevented the rain and the tent, and it wouldn't have prevented the fires. So you're going to have your certificates of insurance for yourself. You're going to make sure your volunteers have got covered. You're going to actually make sure that your contractors can show you that they've got the appropriate insurance. One of the difficulties with insurance, of course, is that if you're running a small event at your CRC or a P&C of a school and you're going to make $2,000 and they want $3,000 or something for the insurance, there comes a point that it's not worth doing. So you need to just be able to talk with insurers' bodies and things like that, and there are things emerging that make it more cost effective for those things, but only if you can demonstrate that you've addressed your risks and that it's a low risk event, because that's what people will be asking for. So again, going back to that planning we talked about last time, the more you know about your event, the more you're likely to save money on insurance. But it's not if you have insurance these days, because that's the only way that anything that happens that you're going to be covered, and also so are the people who have an unfortunate accident. The second part of that equation as well is the Civil Liability Act. Now, the Civil Liability Act, as you can see here, it's a document that actually was first put in 2002, and it's actually legislated common sense. It virtually says that if you've told somebody that an act is dangerous, you've told them also what can happen to them and what the outcome might be, and they still choose to participate in that event, then you're not liable. Now, the trick about that, you see these signs around that say, don't jump off a bridge, which is just a circle with somebody diving and the red line through it. That's not enough. You had disclaimers before where people said, do this at your own risk, and that's not enough. Under the Civil Liability Act, you will be saying, don't jump off the bridge. You could hit your head on the bottom, you could become paralysed, a boat could run you over, whatever, and you could die. That's enough. You would put that into your publications that you send out, this is a high-risk event. One of the ones that's well publicised is motor activities. When you go in, you see that listed everywhere. This is a dangerous sport. We've taken all the steps we can, but you're entering here knowing that you're coming into a dangerous arena. Be hard-pressed then for somebody to sue and say, I didn't know. However, you've got to remember we are a multicultural society. We have people that are hearing impaired, vision impaired, so you have to do it pictorially and in other forms. It's even acceptable to verbalise it over a loudspeaker or as people come in. But it has to be that if you're having an event that is a high risk and people are participating, that they know what they're doing. The other sort of risks are obvious risks. People often ask, why is a swimming pool fenced and not the river? And the answer to that one is that people can see the river. So if you're having an event near a river or a lake, that's okay during the day. But at night time, if there's no lighting, it's not an obvious risk anymore. So you have to put something in place, barriers or knowledge about that. The other part of liability in the Civil Liability Act covers is whether you can say sorry to people. Because it used to be that if you said sorry, you were accepting liability. So everybody got very distant and said, no, I'm not going to say sorry, and otherwise they'll blame us. It's a fact when you go and find the reason that people sue in the lower end of things is because they think that you didn't care. So it's all right to say sorry, but you say something like, I'm really sorry that happened to you. How can we help? We'll get you to a doctor. We'll fix something. I'll put you in touch with our insurers. But the Civil Liability Act says that's not an admission of any sort of guilt. That's actually just acting in good faith. So they're the two things that gives you. And that's available from government print. And familiarise yourself with that and make sure that if you do identify some areas that are risky, that you notify people that they're there and what can happen to them, and preferably in pictures. And there's pictorial signs for most things that you can get, and there are websites. If you're involved with the local government insurance services have a manual with all sort of signage that they'll be able to access for you. Okay, so the other thing is your risk register. And your risk register, then all those things you've identified, you're going to put in your risk register. So rather than buying somebody else's risk register, borrowing, sharing, that's all okay to give you an idea of what you might want to look at, but you make sure that it's relevant to your event. Because if you're standing in a court of law and somebody picks up this and says, well, you know, on page 342 of your plan, you said this, what did you mean? And you don't actually know what's on that page, your liability factor just went up amazingly. So our last point that we need to be looking at here is what happens if something's gone wrong in your event. We've talked about if it's going wrong, you need to have the damage control in place, but something big has happened, and first thing is don't panic. Try and be mindful of what's happening, mindful of the evidence you'll need to collect, and mindful of being empathetic to anybody that's involved. So first, get it under control. Don't think about pulling out your tape recorder straight up, but certainly have a camera handy. The second thing is don't shred any documents. You'd be amazed, when I was working with local government insurance services, we'd try to find some evidence and they would go, oh, well, we thought it might incriminate us, so we shredded it. I just need to tell you that that point of not helping people sue you, if you just have a box with all your papers in, give it to the lawyers. Anything that's going to incriminate you won't come out of the box, and anything that's going to defend you, even remotely, will. And often you might have shredded something that could have been evidence that defended you that you weren't aware of. So the thing is, never shred. And also somebody will see you do it and then that's almost admitting you're guilty. So the third thing, as we've said, is treat people with compassion. So if somebody's hurt or damaged, watch out for those people who actually you may have seen yourself, where somebody has a little bit of slip and they run around going, you all saw that, didn't you? Yes, I need some evidence, I'm going to sue. You know, treat those people with some level of respect perhaps, and just say that's okay, we'll just take some photographs, we'll do all this, and let them know you're collecting evidence. They're reasonably rare, those people. The most people are genuine. So it's about, you know, what can I do for you? How can I help? How can we make this better? Can I call somebody? All of those things. And then if you've been nice, unless people have severe injuries, you'll find that they don't sue. It's very rare to find that. You know, you might find that they'd say, well, look, I've damaged something. Can I have a replacement handbag or something? That can usually be settled. The last thing is seek help. The first thing that you would do is, if you've got any inkling that somebody is going to sue you, or that you need to respond to something that is bigger than what you can actually deal with, everybody in your event should have a list of all of the emergency numbers, key contact people, so you get help as soon as you can. The minute any emergency people, police, fire, ambulance come to your site, you are no longer in control of your event in that particular pain. They will give you something to do, like calm people down or do something like that, but they become, by law, in charge of your event while the emergency is going on. And then they'll hand your event back to you once it's been finished. So it doesn't matter whether you're the president or whoever you are, you have no jurisdiction once the emergency services come into your bit, and they'll deal with it appropriately. Then you must inform people as soon as possible. as to what's happened, whether it's your insurer, your organisation, anybody further up the tree who are accountable for you and your activities. Inform them as soon as possible. Follow that up very quickly with an investigation. So everybody these days has a mobile phone with a camera. An example of that might be that there was something spilt on the floor somewhere and there's a slip. The first thing people do is clean up the mess. So once that mess is cleaned up, you've got no evidence either way, whether you're the defendant or the accuser, that it was there. And it might have leaked accidentally out of something else. So take any photographs that you can of any sort of scenes, even if you're randomly taking photographs. It'll be interesting because many a case has been won just on photographic evidence of something in the background of a photograph, not particularly what you thought you were taking a photograph of. The second point is take notes, and if possible, separate people from, if there's 4 or 5 witnesses, do not interview them collectively. Take them separately as soon as possible, because as soon as people start talking, the evidence changes, because they start to think, well, maybe I saw it wrong. So take some notes as soon as you can. The last thing to remember here, and this little cartoon says something's fallen on top of somebody, and it says, I'm putting that down to natural causes. If you haven't got evidence, people will make up what they don't know. And it's pretty hard to defend what people think happened rather than what actually happened. So once you've got all those things, record that. Make sure all your photographs are put into a safe storage place. Thumb drives are better than CDs. CDs apparently deteriorate over time. So put it on a thumb drive somewhere, get it onto a hard drive. Mostly give it to your insurers, because even if somebody doesn't sue for 20 years, the insurer is likely to be still standing, but most of the people that were around aren't. And with that, you're going to have lists of your volunteers, lists of any staff around, who your contractors were, as many notes that you can possibly do of people involved at that time. And then in 15 to 18 years' time, when a child grows up and decides to sue, which they can do, you've got at least a chance of finding somebody who was remotely around at the time. So contact details are very important as well. It's a bit easier these days with internets and Google and such like than it was years ago, but it's important to understand who was around. So in summary of all we've talked about today, the most important thing for you to do is prepare, plan and research your legal responsibilities. Your duty of care is talk to your councils, talk to anybody who might have a stake in some way legally or by virtue of town planning. Consult, communicate and assign responsibility for all aspects. It's more than just consulting, it's actually trying to understand local environments, because you with your event will change what's happening in that environment. A quick example of that environment that I'll give you was a Cable Beach basketball match that was done in the afternoon, morning and afternoon. Morning was fine. Afternoon, the locals did tell the organisers that a dew came in. The organisers, being from down south, said, oh yep, gets slightly damp. A dew in Broome, when it comes down, is a bit like rain. So you've got a slippery basketball court with this very heavy dew coming down, and even though they knew there was little dew, they bought a few towels and things to wipe the court down. They hadn't expected a river. So they had to abandon the match, an internationally televised match. But the good thing was their contingency was, if something happened, that they could reschedule it to earlier in the day for the next day. Respond appropriately if issues arise. You try to say, what's our best way to assess this? And even if you have to stop things, document and photograph and ensure sound long-term record keeping. That is really, really important. Now, before we just wrap up this broadcast, 2 things I want to say is that if this has raised more questions for you than answers, we'll send them through the Westlink email. So westlink@rdl.wa.gov.au. And if you want to have a copy of the PowerPoints, just to remind you through some of these things, through your links with Roz, just send a request through. And if there are questions that come from either of these sources, I'm quite happy to respond to them and send out a summary sheet out through the email of the answers to those. And I'm going to leave you with a poem for you to ponder on. And then I'm going to tell you after that what is on at the next session. So this is called The Ambulance in the Valley. And it's a particular favourite of mine because it kind of drives the way I feel about risk management. 'Twas a dangerous cliff, as they freely expressed, though to walk near its crest was so pleasant. But over its terrible edge there had slipped a duke and many a peasant. People said something would have to be done, but their projects did not at all tally. Some said put a fence at the edge of the cliff, and some an ambulance down in the valley. The lament of the crowd was profound and was loud, as their tears overflowed with their pity, but the cry for the ambulance carried the day as it spread to the neighbouring city. A collection was made to accumulate aid, and the dwellers in highway and alley gave dollars and cents not to furnish a fence, but an ambulance down in the valley. For the cliff's all right if you're careful, they said, and if folks ever slip and are dropping, it isn't the slipping that hurts them so much, it's the shock down below when they're stopping. So for years we have heard as these mishaps occurred, quick forth the rescuers sally, to take victims who fell from the cliff with the ambulance down in the valley. Said one in a plea, "It's a marvel to me that you give so much greater attention to repairing the results and curing the cause. You'd much better aim at prevention. The mischief, of course, should be stopped at the source. So come neighbours and friends, let us rally. It's far better sense to rely on a fence than an ambulance down in the valley." This is a poem by Joseph Malins, and if you think about it, that's the summary of risk management. So the next time you tune into these broadcasts, which I hope are actually working well for you, the next session is on November the 1st, and it's working with the media and local business to promote your event. And there's going to be a panel of experts on this one that will offer you a wider range of information and experience. So think about any questions or information that you might like addressed in those sessions, and also get them through to Ros so the session can be have as much as possible as you'd like to know. So goodbye for now, and we'll see you at the next session.